I'm actually not from the University of Tasmania, although that's where I started. So honourable mention. No, I'm also up the hill at Flinders and part of QSEPS. Okay, so it's good to have some references to ASEAN and to policy changes in the Asian region and institution building in the Asian region, because that really segues quite nicely with what I want to talk about. The conference talks about, the title of the conference is the rules of the game, and I'm interested in the rules of the game more generally, but also with respect to human security and human rights in regional organisation. Behind the question of changing rules of the game is the question of changing ideas and of changes in whose ideas matter, which some of you may recognise as the title of a book from recently by Acharya. And I think both of these are less than straightforward, both whose ideas matter and which ideas are changing. In the context of human rights and in the Asian context, the Southeast Asian context in particular, we have the move over the period of my academic career from the discourse around Asian values now to a new institution and a new discourse that goes with it in the Southeast Asian region of the ASEAN Intergovernmental Commission on Human Rights. And that's the change that I'm interested in this paper. I'm interested in the fact that there is institutional change, there is change in discussion in the ideas that are used, but I'm also interested in questioning what exactly has changed. I mean, superficially or to casual observers, it may appear to be the case that there has been a turnaround in the way in which ideas and institutions of human rights are regarded and endorsed, but I'm kind of interested in questioning to what extent that is the case and how that might be the case. So why and how, what does it mean and what might it mean for human rights politics and for actual human security and well-being in the Southeast Asian region? The development of the ASEAN Intergovernmental Commission on Human Rights, which is a commission that was inaugurated in 2009, is an interesting story in itself in institutional change and institutional development. And for those of you who are familiar with the history and politics of ASEAN, you'll be interested in some of the twists and turns in that, which if you're particularly keen on, I'd be happy to send you the full version of the paper, bits of which this presentation are poached from, but I don't have time to tell that story. It's what we would tell our honours students is falling into the trap of the long run-up, where you tell a long history and then you don't actually have the time to say what you want to say. But those developments, institutional developments, are interesting in themselves. It's also interesting from the point of view of what opportunities will arise out of the new commission, as I'll call it, as an abbreviation. There are already some areas that have been an active part of its agenda. For example, business and human rights, which we may hear more about later, peace building and so on. But there is also an enormous amount of scepticism about the Commission. The civil society organisations within the ASEAN region are not particularly happy with its progress and with what it's been able to achieve. And a lot of that is currently manifested in the contemporary debate, which is going on right at the moment, about the possibility of there being an ASEAN Bill of Rights, what would be in the bill and what it might mean. And if there's time later, I might make a few comments about that as well. I was interested when I sat down to do some preparation for this and thinking about how to translate the material that is in my broader paper about the ASEAN Intergovernmental Commission on Human Rights into the agenda for this conference. One of the things I also did was to sit down and look at a couple of recent issues of the Australian Journal of International Affairs, and the most recent issue has a couple of interesting articles which have a bearing on the sorts of things that we're discussing here. There's one piece in there by, I have to get my references right here, by Melissa Curley, who was looking at human security and non-traditional security issues and the relationship with ASEAN. And she talks about the developments from the time of the ASEAN Charter in 2007, and talks about them initially with, I think, the enthusiasm that a lot of people felt at the time about the potential for this charter to develop a people-centred ASEAN, for there to be more interest and inclusiveness around promoting human rights, for civil society organisations to have more input and so on. And then she also takes up this sceptical theme about what has developed out of that, and both generally with respect to ASEAN and the people-centred agenda, and specifically with reference to the ASEAN Intergovernmental Commission on Human Rights, that in fact we have less than positive outcomes with respect to that. Although she does, one of the themes that she takes up in thinking about how human security might work within the ASEAN region is to talk about localisation strategies. And I think perhaps this connects with what Alan was saying about the internationalisation of some of these themes and some of these rules, that ways in which for this to happen effectively within the region is for as it were, for them to come from the inside out, or to be adopted indigenously, rather than being rules of the game which are imposed from the outside. And the human rights debate, and this is part of the reason why I'm interested in the human rights debate in the Asian region, because it can be seen as an example of possibly how this might be happening. Going from the anti-human rights, Asian values rhetoric and the politics associated with that, to a situation now where ASEAN itself is creating human rights institutions and trying to figure out how to make them work, and where the agenda that goes along with that is not just an agenda that is taken up by civil society organisations and traditional human rights advocates, but is also being taken up much more broadly by government organisations and the like. There is only one full-length study of the book-length study of the ASEAN Intergovernmental Commission on Human Rights by Sein Lee Tan from Singapore. And so, amongst other things, I think it's a really, and particularly for those of you in the room who might be students or looking for career-defining research agendas, this is an interesting one to watch, I think. I'm just going to read a couple of excerpts from my other paper, which perhaps show a little bit of the way in which I'm interested in these changes and in these developments. A central part of what I'm interested in thinking about is how the making of rights claims may change with the advent of the ASEAN Intergovernmental Commission on Human Rights. I'm interested in examining this over a number of different registers. At the governance end of the spectrum, there will clearly be a whole raft of actual and potential changes over time. The very establishment of the Commission, granting it certain, albeit limited, powers and responsibilities, establishing legal and institutional connections with existing institutions and processes within the various ASEAN states. These developments change the mechanical and procedural ways in which rights claims may be made. Assuming that the Commission is in fact effective at progressing its agenda, and this is a point which a lot of people contest, at building new institutions and institutional connections, establishing new forms of international law in the region and the rest, assuming that all this takes place, we're nonetheless still discussing the development and consequences of the ASEAN Intergovernmental Commission in the register of governance processes and procedures. The way in which this is usually discussed strongly suggests that the activity of creating and developing the Commission creates or establishes something where before there was nothing. The region now has a Human Rights Commission, whereas before it didn't. The Commission is drafting a Bill of Human Rights, something which was previously undrafted and thus absent. Rules which did not exist are being established in ASEAN's bid to become a rule-based institution, and so on. This is all true as far as it goes. What's overlooked, however, is the established politics of the making of rights claims in the region, a politics which is autonomous from the Commission, even it has been centrally instrumental in bringing the Commission into being in the first place. The register that I'm interested in examining is the register that sees the making of rights claims as a social and political practice, a practice which may be tied to particular institutions, both before, during and after the existence of those institutions, but also one which may exist autonomously from formal rights institutions and one which may exceed extant institutions and formal statements of which rights exist and how one can claim them and in what manner one can claim them. It seems to me that this is a critical way of thinking about what's happening in the region as ASEAN moves from a time where the social and political practice of rights claiming has been generally disenfranchised and marginalised, often dismissed by authorities and given no legitimacy, to a period in which those same authorities are adopting the language and formal procedures and governance institutions of rights claiming. And so this is my question: is this a happy transition, in inverted commas? Is there a risk that something important may be lost in the transition to a formal, relatively open and procedural politics of rights, assuming that we get that far? And I think that is a big assumption. If the new rights claiming institutions were to be seen as the end point of a politics of human rights in the region, then I think it is the case that something would be lost. But it is not in the nature of rights politics that those intent on claiming their rights are willing to cede authority over those rights to institutions, processes and authorities which they also see as suspect or insufficiently committed to upholding the veracity of those rights. And then the next brief section, which I'll excerpt from, is called Rights and Trumps, and this kind of feeds into the theme about games, I think. So some scene setting for what I want to get at here. While many are delighted about the development of the ASEAN Intergovernmental Commission on Human Rights and the in-development ASEAN Human Rights Declaration, many are sceptical. We saw above, well actually you didn't, but you can if you want to read the full paper, that some people have counselled optimism about what might be achieved with the Commission, but there is at least as much grounds for pessimism. The Commission's terms of reference prioritise and privilege traditional notions of state sovereignty before any reference is made to international human rights standards, and this seems to be continued in the new human rights declaration that's being drafted. The whole exercise is set within the context of the ASEAN Way. In this context, it's not too difficult to see the exercise as an attempt to maintain control through co-optation. It may not be pushing it too far to see this as a second-generation version of the Asian values debate. One can imagine high-level officials saying, if we must have human rights, then we will build the institutions and discourse, and we will maintain them according to our priorities. ASEAN's political interests trump all others, and as trumps, they can be facilitated through the institutional development of human rights as well as through any other means, if done properly. And there, of course, are many, many examples from the West of how to use human rights and human rights institutions to trump non-human rights agendas and interests. I introduced the idea of trumps here deliberately. It's been a central idea in the philosophical literature about what making human rights claims means, but it's also a useful idea for thinking through and getting beyond the politics of human rights, both within the old Asian values debate and in the new Commission era. In a game of cards, to play a trump is to play a card that wins the hand. In the old Asian values debate, arguably this was done very effectively for a time by the political leaders of the day. Ultimately, their trump card was their occupancy of the political executive in their respective countries, combined with their populist deployment of culturalist arguments, which muddied the waters long enough for them to achieve certain political aims and objectives under that cover. The most significant element of what I want to examine here is what goes on with the process of trumping. Trumping depends on a certain level of agreement over the rules of the game. There is some level of implicit agreement in the social, cultural, and intellectual levels which allow the trumping claim to sweep through and win. For a time, at least in some quarters, this was the case with the Asian values debate. For various reasons, commentators accepted the credibility of certain claims, the acceptance of culturalist arguments most famously. And what acceptance of the trump card does then is to close down the discussion, stop the argument, place limits on what is politically acceptable, and in some sense, to some degree, guarantee the outcome. For many theorists of human rights, this is precisely the purpose of rights claims. They are to act as trumps in this manner, preventing the executive, the courts, or the body politic from pursuing certain avenues and constraining outcomes within a certain band of possibilities. Trumping will only be successful, however, if there is that certain level of agreement over the rules of the game. This is clearly an area where there have been changes in the debate over human rights in Asia. The game rules which allowed even privileged culturalist arguments have been substantially removed from the rulebook. At the same time, within ASEAN itself, a premium has been placed on the idea of ASEAN as a rule-bound, rule-following procedural organisation, for which the signing of the ASEAN Charter is of particular note. In this context, a conception of rights as trumps feeds almost seamlessly into the mix. Here, I want to connect philosophical arguments and ASEAN's political practice, and that is part of the goal of the broader paper from which I'm reading. The purpose of doing this is to provoke questions about the way in which we think rights claiming as a social and political practice can be constrained politically by both our philosophical framework and our political and institutional context. And that's where I'll leave that paper. Just a few closing comments. I have no idea how much time I'm up to. Someone needs to dance from the ceiling to get my attention when it's time to finish. Just a couple of comments about the Commission and a couple of concluding comments about how to think about it. I've kind of played this optimism and pessimism off against each other on the way through. The politics of the Commission and the drafting of the Human Rights Declaration for ASEAN at the moment are really strongly inclining a lot of people towards pessimism, I think, particularly around the proposed draft. So I've got a list of complaints that kind of feed into that pessimism. Complaints against the Commission itself, it's operated since 2009, and one of the interesting things about the Commission is that the original term of office for its members is expiring very shortly, so there are big questions about what procedures we put in place to rejuvenate it and have new people or the same people, but how they will get there, and what that will mean politically. So complaints, it's not independent, it's not transparent, it's not effective, it has a weak mandate, it's handicapped by consensus decision-making processes. The Commission itself doesn't possess communication functions such as being able to hear cases from individuals, organisations or groups of people, and it's not accessible for other purposes either. There has been a really strong curbing of the diversity of civil society voices that are allowed to participate in the discussion by the exclusion of many groups denied official registration and legal recognition by their own governments, by the Commission. So the Commission won't recognise you if you're not already recognised by your own government, which is fine in some countries and not particularly happy in others. I've already mentioned the terms of reference of the Commission, which undermines the universality and primacy of human rights, and the importance of the non-interference ASEAN principles. Complaints against the proposed Bill of Rights. The Bill of Rights is supposed to be presented in November, so this is very, very current, but this is part of the lack of transparency issue. Nobody has, or very few people have seen the current draft. There was an earlier leaked draft that some people managed to get hold of and circulate. One of the great concerns is that the proposed document will fall short of international standards, that it won't represent international best practice, that in a significant departure from other human rights instruments, there is the need in Articles 6 and 7 of the draft declaration that has been leaked need to balance human rights and fundamental freedoms with the performance of corresponding duties that every person has to individuals, to the community and the society in which they live. And in Article 7, the realisation that human rights must be considered in the regional and national context, bearing in mind different political, economic, legal, social, cultural, historical and religious backgrounds. And when that is combined with concerns with statements in Article 18 about the importance of public morals, and with other issues such as the exclusion of sexual orientation and gender identity rights or rights for women, there is a great concern that the standards that are being set by the document won't be those that are generally thought to be international human rights standards. So that's where the scepticism and the concern is up to at the moment. So just to conclude then, the rules of the game for human rights in this context, on the one hand, they're internal to the region, and this perhaps is where there are real positive developments. And as I mentioned earlier, that the rules of the game are being developed internally and discussed and owned internally, and both within governance mechanisms within countries, between countries, and in civil society. So that's positive. And also in terms of the rules of the game, well, this is more questionable about the external engagement, particularly. So I've just been talking about external engagement at the level of standard setting, but you could also talk about external engagement in terms of how different kinds of institutions hook up with one another and so on and so forth. The big overarching question, I suppose, this goes back to my theme about Asian values versus the ASEAN Intergovernmental Commission, or whether the devious kind of way the Commission is a way of reinforcing the Asian values theme. Is it genuine change or is it just window dressing? And in what sense? My view, I suppose, is that there is very significant genuine change, but that it's not necessarily, it goes in many different directions, and it's impossible to sum all of those up under one heading or with one evaluation for positive or negative. And finally, and to link into the theme of the conference, are we changing the rules of the game or just gaming the rules to rule the game? Okay, thank you very much.